While the Goldberg Law Office seeks to create a very efficient and simple process for you to draft up your wills and powers of attorney, there's still a significant amount of time taken to craft the language within the documents, and yet more time will be needed to customize them specifically for you, so that they're not only effective in the state of Texas, but also represent what you want. However, the only way for us to get these documents right, so that they best suit you, is for you to consider the following questions and answer our online confidential questionnaire accordingly. Who should be in charge of your affairs, i.e., your power of attorney agent, should you be incapacitated? Should there be more than one, perhaps one agent to worry about the business and the other about your personal affairs? Any alternate agents should the first be unavailable or unwilling to serve? Do you wish to impose any limitations on their power, perhaps prevent them from being able to sell your land or other specific assets? Who should be in charge of your children if you're incapacitated and the other parent is also incapacitated, deceased, or out of the picture entirely and without custody? Should there be any limitations on the power of attorney agent over your children, such as the limitation on removing the children from a specific school or maintaining a certain diet? Do you wish for these powers of attorney to be effective immediately or only upon your own incapacitation? Immediate effectiveness does not mean that the agent assumes power immediately, but you can define when that might be. Should the determination of incapacitation be made by a court, which could reduce fraud but take a lot longer, or by the agent or by the treating physician? Do you want your agent to be compensated for his or her time or only for their expenses? While a spouse or parent serving as an agent might do so out of love, a business partner, friend, or colleague might be your only option or a far better one. But they might be incentivized to do all the needed work only if compensated for their time. As to the will, what assets do you now have? Land, jewelry, business interests, stocks, gold, oil royalties, vehicles, 401k, bank accounts? Do you own it 100%? Or are you only giving away a certain percentage because someone else also owns it, for example, a partnership? If you're married, did you obtain these items before or after the wedding? Meaning, is it your separate property if obtained before the marriage, or common property, i.e. owned 50%, 50-50 that is, in an undivided interest with your spouse? A classic example of how this can play out is an individual purchases a residence while single or engaged for the couple to live in. Then the wedding occurs. The house is the individual's separate property and can be gifted entirely to the surviving, non-owning spouse or to others entirely. The only protection then, if gifted to others, is that the surviving spouse who resided within that house is still allowed to live and reside there until the end of his or her life under certain conditions, despite lacking ownership. To whom or to what organizations do you wish to leave your assets? All to your spouse? What if she passes before you or leaves you? All to your children, aside from what your spouse owns? Some to a particular charity or nonprofit? Is it to be used for any specific purpose, a particular entitlement? If so, then we strongly advise you to enter some specifics that will allow your future executor to get the gift to the right institution. That is, don't just list the Red Cross, but rather the Red Cross Houston Division, care of the Hurricane Relief Fund, as an example, unless, that is, you don't mind the funds being sent to the global entity. Whom do you trust to serve as the executor for your state to manage all of your affairs post-death and to distribute the assets? Perhaps it's your spouse, but perhaps you don't wish to burden him or her at their time of grieving. Then again, perhaps he was never responsible with paperwork or budgets. Should your executor be compensated for his or her time? Do you have any minor children? If so, then you must consider who the guardian will be should their other parent be incapacitated, deceased, or out of the picture and without custody. A guardian may be an individual, whether single or married, or you may choose co-guardians, though they would have to be married so that your kid won't end up having some custody split. Do you have any adult children you'd be responsible for should they suddenly be hospitalized or incapacitated? If so, do they have powers of attorney naming you as the agent? Final point. Our online questionnaire might not give you all the opportunity to express in detail what you want included. Don't worry, hang tight. Get through the questionnaire, choose the pre-price flat rate package that you wish to pay for it, and then send us an email to info@lawgoldberg.com, which will include whatever more you want us to consider or to draft into your will or power of attorney. Or wait for us to send on over the documents for your review once we get them drafted, and then tell us what else needs to be edited.